but there was a second debate as well. And that was over what the Second Amendment actually protects in terms of weapons.
Right.
And it's probably going to sound pretty weird to modern audiences, right?
Yeah, it is. I mean, the view today, and partially because of the Supreme Court and what we're now seeing California argue in the briefing we were talking about earlier, and Duncan and Miller and all these cases, is that the Second Amendment is not meant to protect weapons of war. It's only meant to protect your weapons of personal defense and maybe your hunting guns, but definitely not weapons of war. And what we see is in the 19th century, all these writers, not all, but several of these writers, the ones we focus on in this article, said exactly the reverse.
Right. Well, that was the debate.
Yeah.
The debate was the reverse.
Yes,
right?
yes.
You had people who would say basically this is protection of all arms, or really not. They might not even touch on this idea, but. And so it's sort of implied that it protects all arms.
Yeah, they said there was no conditions express or implied, like that quote we read. Yeah.
Yeah, there were people who said there's just this. Here's one right here. Thomas Cooley, who was Chief Justice of Michigan Supreme Court from 1864 to 1885. He wrote in 1898 that there's no there need. The people shall have the right to keep and bear arms, and they need no permission or regulation of law for that purpose. So basically, you have guns, whatever guns you want.
And we should note here, I know we're drifting to another topic, but real quick, Cooley also expressly rejected the militia view.
That's the other interesting thing about his quote.
He's probably one of the most famous commentators here in terms of modern day citations. And he wrote, "It may be supposed from the phraseology of this provision that the right to keep and bear arms was only guaranteed to the militia." But then he writes, "But this would be an interpretation not warranted by the intent." So I'm wondering if maybe, it'll be an article for another day, but maybe that's where this collective rights view started to rear its head, if he felt the need to respond to it.
Period. Yeah. Right around the turn of the century.
Yeah.
That would make sense, because that's when, a couple decades later is when you start to get the first federal gun laws.
Yeah.
The National Firearms Act of 1934 was, it's about 35 years after this quote. But to finish that quote, he said, "The meaning of the provision undoubtedly is that the people from whom the militia must be taken shall have the right to keep and bear arms, and they need no permission or regulation of law for that purpose." So, obviously, yes, some people viewed the Second Amendment as protecting a practically unlimited right to everyone for any sort of firearm. Now obviously there's there's plenty of other debate on that topic that we'll get in. I'm sure we can get into it another time. But the other side viewed it as a more limited right, but not in the way that you would hear in modern parlance.
No, not at all.
But that it only protected militia guns that would be useful in war, essentially. For instance, we've got Joel Prentice Bishop, who was an influential, you've described him as an influential legal mind of the time who's now drifted into obscurity.
It's correct. But he's only mostly cited now, so in family law circles, apparently. But anyway, go ahead. Sorry.
But he wrote in 1868 that the provision protects only the right to keep such arms as are used for purpose of war, in distinction from those which are employed in quarrels and brawls and fights between maddened individuals. So, and this, there's several other quotes along this line. There was Black, right? Who?
Henry Campbell Black of Black Law Dictionary fame.
Yes,
he wrote
who is pretty well known still today and commonly cited in discussions of the Second Amendment as well because of the dictionary, right?
Right, and he said this right is not infringed by a state law prohibiting the carrying of concealed deadly weapons, but a law which should prohibit the wearing of military weapons openly upon the person would be unconstitutional.
Yeah.
So that's wild in today's context.
Yeah, the debate in the 19th century is pretty interesting to look at. But even with these people who believed that there was some limit to that basically the government could limit guns that they associated with criminal behavior. As Bishop said, those which are employed in quarrels and brawls and fights between maddened individuals. Like even the people who took that position on limits to the Second Amendment, they still believed it was an individual right. Correct?
Correct. I mean, there's no other way to interpret it. They just saw it as an individual right that was limited to military weapons. A state could restrict, the common one at the time was small knives, small pistols, concealable weapons, those kinds of things that would be, as he said, useful in brawls. But they could not restrict the prevailing military arms of the era, which it should be noted. And I don't mean to get into the whole dumb musket debate here, that some people make, but it should be noted that by this time in the late 19th century, repeating arms are common. So we weren't just talking about your single shot musket. We're talking about, lever action rifles, revolvers. I mean, they said certain handguns could be bad, but not the giant, non-concealable handguns.
Right.
So these were,
Black's quote is from 1895. That's post-Civil War. You're getting closer to the modern era there in terms of gun development. But to emphasize the point that even those who held that view still believe the Second Amendment protected an individual right. We have Charles Humphrey, who wrote in 1822 that, quote, riding or going armed with dangerous or unusual weapons is a crime against the public peace by terrifying the people of the land, which is punishable by forfeiture of the arms and fine and imprisonment. But here it should be remembered that in this country, the Constitution guarantees to all persons the right to bear arms. Then it can only be a crime to exercise this right in such a manner as to terrify the people unnecessarily. So, he's saying that people could be locked up and have their guns confiscated if they're riding around attempting to terrify people. Basically they're criminals trying to cause, they're trying to cause trouble, actively doing that, then you can lock people up for it. But the right to keep and bear arms is guaranteed to, quote, all persons.
Yeah, and this is another one of those writers that was from a very early time, 1822, the beginning of the 19th century, almost a contemporary of the founders. Some of them were certainly still alive when he wrote. So this is that makes this, I think, even more persuasive. The earlier they are, a lot of the times, if they saw it this way, then I think that strengthens the persuasive value of it.